The court had been in holiday recess for a couple of days. Today, we will continue the defense case. The witnesses will take the stand over the week in the court, including several members of the jury from Breathitt County. While the defense case was not as explosive as the plaintiffs, we shall see that the defendants do put on an interesting case for their innocence. Come along with us as the witnesses are called to the stand. All aboard the Kentucky-Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine, but it convinces YouTube that we need a bigger time machine to reach more people who love history as much as you do. Now, back to our story. Where we are in the case. The newspaper, the Evening Bulletin, gives us a great start to how the case was going and how many witnesses will be called to the stand. Quote, Marcum damage trial. The case was resumed after a couple of days of recess. Winchester, Kentucky, December 28th. After a recess of a couple of days, the trial of the Marcum case was resumed Tuesday, and about 20 witnesses for the defense answered to their names. So far, the witnesses examined Tuesday have been clerks in the Hargis Brothers store. They agreed that when Marcum was killed, that Tom White came across the street at once from the courthouse, that Judge Hargis ordered the courthouse searched, and that the searching party found nothing, that Hargis expressed a desire to find out who did the killing and the willingness to issue a warrant for his arrest. Captain Ewan, who was with Marcum when he was killed, repeatedly said that he did not see who did the killing, unquote. Anyone who has worked in a store can tell you that you generally have more than a few clerks working there. Here, we have several store clerks that directly contradict the testimony of Henry Hurst. They all got onto the stand to state that Judge Hargis had wanted the courthouse searched for who killed Marcum and was willing to swear out a warrant for their arrest. Were these witnesses afraid that they could lose their jobs, or worse yet, be placed on a list of people that would be ambushed? It's hard to say. However, these witnesses were willing to testify that Judge Hargis wanted to find the person or persons who was responsible for the crime. Was this an act of feigned innocence on Hargis' part? We cannot say for sure, but he did call for the courthouse to be searched. Other witnesses. But they were not the only ones to bring up this evidence. According to the same article, quote, the testimony Tuesday afternoon in the Marcum case was not of a sensational character. Several witnesses testified as to the familiar facts to the killing of Marcum, that Judge Hargis ordered the courtroom searched without effect, and that he expressed an earnest desire to capture the assassin, that Ewan declared that he did not know who killed Marcum other than the facts that we have previously brought out, unquote. Who were these other witnesses? Were they the customers of Hargis Brothers store? Were they present during the shooting? Why did Captain Ewan say that he did not know who the killer of Marcum was if he was standing right next to him? What other facts had been previously brought out that the witnesses were now giving testimony to, without actually standing in the courtroom or having an actual trial transcript? These questions must go, for now, unanswered. The reputations of several members of the witness list for the plaintiff came into question during the trial. According to the same article, quote, several witnesses declared that the reputation of Captain Ewan for truth and veracity was not good, and the moral character of Ruck Cottongang and his wife was bad, unquote. Why were the moral character of Ruck Cottongang and his wife called into question? What crimes had they committed that made everyone think that they were not trustworthy? Why were they calling Captain Ewan a liar for his testimony? What reason or gain could he have attained by giving false statements? The Breathitt County jurors testify. This was huge. Rarely do you have jurors from one trial willing or even asked to testify in another trial. However, the defense felt that they were needed to debunk the testimony of Henry Noble. According to the same article, quote, Several members of the special grand jury, which investigated the death of Marcum and indicted Tom White and Kurt Jett for the crime, were present to testify that the testimony of Henry Noble on this trial was different from that given before that body. Judge Benton decided that they might testify and that Noble was before it, but that the secrets of the grand jury room be kept inviolate and should not be made public, unquote. So, their testimonies were limited. They were not allowed to discuss the deliberations or what evidence they did or did not consider. They were only allowed to speak to the final decisions and conclusions that they came to as a collective whole concerning the evidence given to them. Concerning the matter of Henry Noble. There are many judges that highly respect the decisions of their different juries and do all that they can to make sure that their identities and deliberations are kept secret until after the trial, at which point a jury can be self-identified or they can remain anonymous. Very rarely do we have juries that are willing to speak in cases about what they believed and what they didn't believe in a case. So for the defense to call a previous juror to the stand was interesting to make their case. It is also interesting that Judge Benton allowed their testimony on the stand. This question had been brought before the Supreme Court in 1892 under the case of Maddox versus the United States. Because of the ruling of the Supreme Court, Federal Rule 606 was established. It has gone through many changes over the years. Today, as it is written, Federal Rule 606, Jurors' Competency as a witness states, quote, at the trial, a juror may not testify as a witness before the other jurors at a trial. If a juror is called to testify, the court must give the party an opportunity to object outside the jury's presence during the inquiry into the validity of the verdict or indictment. 1. Prohibited testimony or other evidence. During an inquiry into the validity of a verdict or indictment, a juror may not testify about any statement made or incident that occurred during the jury's deliberations, the effect of anything on that juror's or other jurors' vote, or any juror's mental processes concerning the verdict or indictment. The court may not receive a juror's affidavit or evidence of a juror's statement on these matters. 2. Exceptions. A juror may testify about whether a. Extraneous prejudicial information was improperly brought to the juror's attention. B. An outside influence was improperly brought to bear on the juror. Or C. A mistake was made in entering the verdict on the verdict form. Unquote. So, the question becomes under this rule. Would these jurors have been allowed to testify as to what they heard and ruled upon concerning the testimony of Henry Noble? We will again leave this to you, our 13th juror, to decide upon this matter. In our next video, we will cover the plaintiff's closing arguments and the questions put before the jury. Thank you. We at Kentucky Tennessee Living would like to thank you for watching our video series on the Appalachian feuds. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification. We thank you for continuing to support Kentucky Tennessee Living as we are discovering the mysteries in Appalachian history.